on YouTube as well. Hi everyone. So just give everyone time to join us.
Get it sides.
And hi everyone. And whilst we do that, I'm gonna add both your socials to the YouTube stream so that people can know where to find you. So
Yay.
it's always good fun on YouTube. I like YouTube though because you can actually
Do a lot. You can change and
yeah, you
edit.
can change and edit. Hi everyone. Looking very judicial. Thanks. I've got my high
Yeah.
protective blouse on, looking judicial. So I'm gonna mute you on here so that when you join me on Instagram, we're all
It doesn't echo.
so just to let everyone know, this is also streaming on the Legal Tea with B YouTube channel if you're more comfortable watching on there. And if this live runs more than an hour, then Benny and I are actually going to just carry on because we're going to still be live on YouTube. So that just lets you know you can
Oh,
catch
I did
on
see
either
color.
platform. Hi, everyone. We're going to still be live on YouTube. So that just lets you know. So I'm muting this, okay?
Okay. Give me one sec.
Hi, hi. So we've got Benny in the house. Send me a request, please, Benny, then we'll get started.
Yeah, give me 1 second.
So we've got Benny in the house. Hi, everyone.
Wait, how did it go? Oh my gosh, I can't even do that. How do I do?
Okay, Benny, I'll request you.
Okay, cool.
Okay, Benny, I'll.
Yeah.
Hi.
Hi. You're right.
Hello, I'm good, thank
Wait,
you.
do I mute myself on Skype, by the way?
So just mute the Skype call.
Yeah, wait. Oops.
Is that better? No, don't mute your microphones. Just mute the
Okay.
actual laptop.
Laptop. Yeah, wait.
Because we still need to hear on
Wait.
YouTube.
Can you still hear me on Skype?
Yes.
Cool.
All's good. So I'll just double check. So if you just give me one sec. Oh, say hello to me.
Hello.
Yeah, we're all good on Skype.
1 sec. Oh God. Oh gosh. 1 second.
No worries. I'm going to let the world know that we are live.
We are
Hi,
live.
everyone. We're just setting up, getting the live started. So, like I said before, this live is also happening on YouTube. So, I'm just tweeting as I always do at the start. And Benny, whilst I set up and do the tweets, do you want to introduce yourself to everyone, please? Just say hi.
Hello. I'm Benny, and just like Blessing, I've done the BPTC, and just like her, I'm a baby barrister, and we're gonna talk about the Belly Mujinga case today. So yeah, I don't know what else I can say.
Just that you're amazing, but that's my personal opinion.
Thank you.
Um, thank you. So we've planned out. So Benny has done amazing research into this for you guys. So I just wanted to start by thanking her. Um, and hopefully we're gonna clarify some really important things. And we were discussing this earlier whilst we were planning. When it comes to the law, it's sometimes disappointing, but it's still important that you're knowledgeable about the facts and the information, and that's really what we want to do for you today. So I'm just gonna put the links on Twitter because that's where everybody needs to find us. Um, yeah, so if anyone does want to share these links with anyone to the live stream, please just go to Twitter and you can find the tweet that
Did
I'm
you
just
want
about to put out now.
what was so they know some weird?
Would they pardon?
Would you want to pin down what we're going to be talking about so people know when they join?
Yeah. So what we're going to talk about. So I mean, I don't want to jump. So you jump in, if you want.
Okay.
But right now we've planned that we're gonna discuss firstly an overview of the case. So what happened, and then we're
Hmm.
gonna get into the British Transport Police. and their original investigation. And possibly, I think it would be great if we covered why it was the British Transport Police and not the Metropolitan Police or whatever. People may not um, be familiar with
Understand why
that.
it went. I
Yes.
don't want to mess that one up. I'll try.
And then we're going to look at the CPA, the CPS, that's the
Yes.
Crown Prosecution Service, their investigation into the evidence in the case and what that actually means for the case as well. Because I think it's important that we clarify what it means and also what it doesn't mean. And Beni is very, very much the criminal queen here. So she is very much interested in the criminal element of this case. And I'm going to talk a bit about the civil element because there is a civil element to this case as
Yes.
well.
One sec. One sec. No, you carry on talking. I'm still here.
Oh, I thought you wanted to jump in. Okay.
Still here.
So I'm just going to make sure that all is good with the YouTube live stream.
Uh-huh.
Okay, the YouTube live stream is okay. So now we've got all
Is
of
it ready to go?
our tech ready to go. So, um, Ben, did you want to start with the sort of like factual overview of who is Belly Mujinga, what happened, and why are we here?
Well, Mrs. Mujinga was a mother, a daughter, and a wife. She was 47 years old. Forgive me if I keep looking to the side. I'm looking at my screen.
Same.
She was a railway ticket officer working in Victoria, and she was employed by Govia Thameslink Railway in London, Victoria. Um, Mrs. Mujinga had already had underlying respiratory problems, and she was cuffed and spat at whilst working at the ticket hall on the 21st of March 2020. Subsequently, she ended up passing away on the 5th of April after testing positive for coronavirus, leaving behind her husband and her 11-year-old daughter Ingrid.
Thank you for that. I was just making sure that all of all of the information is coming out, and everything's all right. But thank you very much. And I really appreciate and value that you really explained that Mrs. Mujinga was someone who meant a lot to a lot of people, and
That's so important.
it is, right? And we were talking earlier about really humanizing people when you're looking at cases like this and not sort of brushing it off. Because as your
Mm,
research showed, she was failed at pretty much every level.
mm,
And this is a really important case to cover. So I think what I'll do now is I'll jump in and I'll sort of give an overview of why it was the British Transport Police that was involved, and then
mhm.
if we go into the actual discussion of the first British Transport Police investigation, and
Yeah.
we'll just discuss it between the two of us, and back and forth. I want to remind everybody who is watching, whether you are watching on YouTube or whether you are watching on Instagram, you can ask questions. Please jump in and ask your questions as we go along and through in the stream. If you have questions about any legal principles, please ask those and we will clarify to the extent of our knowledge. If we can't do it in a very quick like search, then we might have to like hold that question to answer later. But generally, we're going to try and ask everything you have to ask here and now today. Um, so, an overview of the British Transport Police. So, most of you who have traveled, been at train stations, or have seen those signs referring to the British Transport Police, we do have a specific police force who works on our transport systems, and they essentially police people's behavior there. And in any event and any sort of criminal acts that arises from use of transportation or in and around transportation will be investigated by the British Transport Police. And that is why this case is in their jurisdiction. I wanted to clarify that in case anybody wasn't familiar with the difference and wasn't aware. So after Mrs. Mujinga died, they opened up the case. The British Transport Police investigated, didn't they?
Yes.
So did you want to go into that investigation and what went down?
Well, the BTP, what I'm going to call them now, they claim to start an extensive inquiry on the matter by beginning an investigation through interviewing a 57-year-old man involved in the investigation. They had received statements and reviewed the CCTV footage and claimed that there was no evidence of the spitting incident. The senior detectives actually were confident in saying that the incident did not lead to Mrs. Mujinga contracting COVID-19 because they claimed that in the CCTV footage, detectives interviewed, as well as interviewing the 57-year-old suspect or man, they saw that he tested negative for the antibody test for coronavirus. However, and that was in the time after the accident. However, the question then arises that did they even observe the tape if they said that they just checked his results for the antibody tests?
Mm-hmm.
And we now know that some of these antibody tests were not actually accurate. So perhaps we might need to venture into looking at retesting the individual by perhaps an independent doctor. Nonetheless, the BTP decided to close the investigation, quoting that they've reviewed all the evidence and senior detectives were actually satisfied that the incident did not lead to Mrs. Belly Mujinga's death. And that is their investigation.
So it was the closing of that first investigation that really kicked off the campaign for justice for Belly Mujinga, because it was believed by a lot of people close and around the case that justice wasn't served. It wasn't satisfactory that it was just said that there was no connection. And one of the biggest things I've seen people asking for was to release the footage. So I wanted to discuss just generally. I mean, we've seen it before on things like Crime Watch, and when the police come online on Twitter, they have done things like release CCTV footage to the public. So it's not unusual that it would be released to the public, but it hasn't so far. And
Yeah.
what I wanted to say and what I wanted to discuss with you is when it comes, so I mentioned this in an earlier live stream, but when it comes to actually closing a case off and making that decision, it is possible for those decisions to be challenged, isn't it?
Yes, yes, they can challenge it. There are commissions that you can access to challenge those cases like that, whether it's CPS or the police. Those options are available, but thankfully, I just want to say shout out to Black Lives Matter movement in the UK and abroad, because if it wasn't for them, I don't think we would be able to say that the CPS is now reviewing the case. So, but yeah, there are options to ask them to review it, if that makes sense.
Yes. So there's sort of internal things, and then there's also external
Exactly.
challenges that you can bring. So we did discuss this, and this was a big point that we wanted to make clear for the stream. Um, does the fact that the CPS is investigating mean that her case, the original British Transport Police case, is open?
Yeah. It does not mean, I just want to say as well, just because the CPS is reviewing the evidence, it does not mean that Beni Mujinga's case has been reopened. That is not the case, unfortunately.
And that is the disappointing element that we knew that is important that we clarify, and we wanted to get that out there, that the case itself is not reopened. The British Transport Police hasn't changed its own position, and the as you said in your summary, Benny, they've stated quite confidently that they don't think there's anything further to be done in this case. They don't believe anything further needs to be done in this case. They believe that this case has gone as far as it can or needs to go.
Mm-hmm.
And so when it comes to challenging this decision, I think it's important that we acknowledge that as far as the police are aware, whatever goes on with the CPS reviewing the case from now on, they don't believe that they need to reopen it, do they?
No, they don't believe there are any grounds to reopen it. They claim they've used all the evidence and they believe that there was no assault on Ms. Mujinga leading to her undeath.
And when we were talking about this, and there's a strategic element as well to having the CPS review the evidence, isn't there? Um,
Yes, there.
and that we wanted to emphasize, I mentioned again in that earlier live stream where I talked about when it comes to judicially reviewing a decision to close an investigation or a decision not to investigate, it's a difficult area. Generally speaking, it's not believed that unless you're sufficiently close to the matter. So, for example, the police failing to act on evidence that your life was genuinely at risk, now, that is something that could be investigated. The difficulty is when you want to prosecute, or sorry, not prosecute, you want to challenge a decision not to charge or raise a prosecution, but it doesn't directly affect you. That is the difficult part of challenging police decisions. But in any
Yeah.
event, were there to be a challenge and the CPS were to return a finding that they don't believe that the evidence supports a prosecution, it would be strategic in the sense that it would be very difficult to bring that kind of challenge, right?
Yes, it's very tricky to prove that that particular incident led to her having been infected with COVID-19 and leading to her passing away. That's the
Yeah.
difficult aspect to it.
Um,
But I feel we should fully break it down
okay,
for
let's do
people to
it.
understand how we got to that conclusion.
Let's do it. Let's start.
So, I don't know if you want to start with the employer's duty aspect because I feel that it's important because the question is, why is it that Miss Mujinga, who had respiratory issues, why was she working so close to people when COVID-19 was rampant in the UK?
And that is a big question. That is something that a lot of people have raised and addressed. Now, thank you again for all of your extensive research into this,
Yeah.
because but really it is, because what you had found is that in this case, Mrs. Majinga had no PPE, so that's personal protective equipment, and she had begged to be let to work from inside the building rather than outside on the concourse. Now, what does this raise? This raises issues of employer negligence, and negligently failing to provide a safe work environment. So, say for example, you work in a factory where there's heavy machinery. It's your employer's duty to make sure that environment you work in is safe. Now, with the
At all.
coronavirus creating these new requirements upon employees, especially employers of essential workers, people who have maintained working in transportation and our health services, the standard required to provide a safe work environment has changed. And employers failing to do so is likely to be seen as a breach of duty of care. Now, this is where this case divides into criminal elements and civil elements. So I want, again, like we said at the beginning, if you have questions, please jump in. When you feel like we aren't making sense, please let us know. So we've got a question on the refusal. So Genevieve has said, why did they refuse her request not to work directly with the public? Benny, in your research, did you find anything on the employer on when you looked at what the role of the union or any of the challenges? Sorry, any of the investigation into the fact that she didn't have PPE? Did you find anything that spoke to that?
Yes, interestingly enough, I did, but not too much. Her colleague said that Miss Mujinga was very adamant that she covers her face at least, or that she'll be sent to work in the back office because she knew that she had breathing difficulties. However, her employer didn't deem it as important and felt that she was better off working front line. And when they asked her, they forced her pretty much to work for front line. She was saying that she wanted to wear her own face mask to protect her face in order to ensure that she can still breathe properly and no droplet can get into her face. The employer was very adamant that they were not to wear any private personal protection.
So private PPE.
private PPE was not allowed. And at that particular time, it was just, I think, before the lockdown, they said no PPE. We don't have any PPE to give you, so you just keep working where we tell you to work.
That's insane. So
Yeah.
that failure, so that refusal, and also unreasonably preventing her, especially now it's a government directive that it's mandatory to cover your face when using public transportation.
Yes.
So these are where you find the grounds for finding somebody has been negligent and has they yes, exactly, Genevieve, by
Yeah.
putting her in a dangerous position. That is it's unreasonably negligent. So
Excellent.
there is, you know, the courts will take, for example, there's case. So for example, there's one case that I'm remembering vaguely from law school where I think it was at a swimming pool or something like that, and they hadn't quite. Well, I don't know if it was a swimming pool, it was, or a factory or something, but
Hmm.
the amount of water that was there, it wasn't reasonable for them to have been able to clear it all very, very quickly. They needed a few hours or something like that.
Oh,
So
that's
when
sorry.
pardon?
There's a
Oh,
question there. Can the family get compensated for their negligence? That's
generally speaking, well, we yes, essentially, it would be if there was a finding of negligence, then the award would go to her estate or whoever's brought the action on her behalf.
hmm
Um, because the employer owed her a duty, and then it would be the action would be brought on her behalf as a deceased person, which can be done and does happen. So when it comes to the employer and their actions, like I said, it's unlikely that it's going to be found that it was reasonable to refuse her to wear private PPE, given that she had respiratory problems, and given that although it was an early stage before we'd reached where we are now, it was
hmm
still reasonable at that time to want to cover your face, to want to keep yourself safe, especially if you had respiratory problems.
Requesting work in the back office. She didn't say, I'm not coming to work. She said, just put me in the back office. I'll still be here.
Um, Thank you for your question, Raisa. So it's not British Transport Police that would have this claim. It would be her employer, and her employer would be who would be the defendant in this case. Evidence from the British Transport Police investigation may be brought into it, but it's not necessarily the case that you would be able to bring an action against British Transport Police themselves. We've got another question. Will her family seek legal action?
Legal action. At the moment, we are not quite sure, but what we do know is from her family that they want as many people to sign the petition, talk about the situation, and protest.
Yes. And they have also shown, I think Belly Mujinga's husband, Mr. Mujinga, well, I don't know if his surname is Mujinga, but Mr. Mujinga was at the protest as well, and has
Yes.
shown support for everybody protesting for Black Lives Matter in the UK,
hmm
and also donating to the GoFundMe. I'm going to put the GoFundMe in the link to the description for this video for everyone on YouTube. And then everybody on Instagram, also click the link in my bio. Um, and thank you, Genevieve. Yes. So um, I think it's also important to remember in these cases that any civil case may take a while to actually percolate its way through. Whereas with these criminal decisions, it may seem they're coming to this decision very quickly. It seems very quick. Um, and just to compare between the two, sometimes with criminal, with civil, you've got to play the long game, and you've got to go through a lot of procedure, and there's a lot of process and rules. But generally speaking, if there is a case to be made of this being negligent to the extent that her employer caused her death, then you could be seeing awards of damages. Now, when do you want to get into the breakdown of causation and the civil element, or do we want to now discuss the CPS reopening and what they're actually going to be looking at when they're looking at the evidence.
Sure. I feel like we should kind of go into the phrase CPS reviewing evidence, okay?
Yeah.
So let me just go back for a second. And the decision originally made by the British Transport Police was that there was a decision to incorporate uh, they decided not to press forward with the case. However, they now backtrack thanks to the Black Lives Matter movement, saying that the CPS will conduct an independent review of the available evidence and whether there are any further lines of inquiry. So, the job of the CPS now is to apply a test when making a decision about whether to charge someone or not with a crime or not. So, with this, we have a two-stage test. I don't know if you had a look at it. The
I've
CPS,
seen
the
it. No,
two.
I've got your notes here.
Okay, cool. So there was the evidential stage, which actually the British Transport Police took over, and they said themselves that they were not satisfied enough with the evidence in the Mujinga case, therefore felt it was unrealistic, in their own words, for any prospect of conviction against the suspect of any charge. Okay. Thankfully, through the Black Lives Matter movement, it's become a public interest. So the CPS somewhat skipped this two-stage test and went to stage B, stage two, which is the public interest stage. And in that, it means that we can really say that Black Lives Matter movement caused the legal shift in her case through pushing it through activism, showing that her life matters first and foremost, and that she should be granted justice accordingly. So the CPS now will balance factors for and against prosecution carefully and fairly decide how important each and every factor of her case is to make an overall assessment of whether we can take it to court and get a good conviction or not. So every case, we have to remember, every case is unique. And especially Belly Mujinga's case, it's unique in its own terms. And it must be considered, the CPS will consider it on its own merits and on its own facts, okay? So at the moment, we the public, because me and you both are the public as well, we don't actually have too much information on the factors going in the case. But assumingly, what I could gather from my research is that factors that can be considered is the spitting assault, which caused an unworkable and unsafe working environment for her. And the colleague, we have to remember, Billy Mujinga wasn't alone when it happened. She had a colleague right by her who also caught COVID-19 following events of that day. So another factor they can consider is that the employer forced Ms. Mujinga and her colleague to continue working on the concourse even after the assaults. And the prohibition from her employer from wearing any protective masks. So in that all, we can see that her employer, most and foremost, treated Mujinga as somebody who's merely disposable. Because if you know your employee, who you have duty of care for, has been spat at, has been assaulted and cuffed at, why would you make them go back and work?
And that's the question that would be raised in any civil action against the employer. So we've had, thank you so much for that. And we've had some questions that I wanted to address.
Yeah.
So Rosie has said, what can we do now the case is being reviewed in comparison to what action was taken after the case was closed? Is there anything more we can do now? Thank you for that question. In a sense, we have to wait. We have to wait to see what comes out evidence wise. I think what we can continue to do, as the family has said, is to continue to push for awareness for this. I think what would end up happening is that the CPS will probably publicize its decision and its review of the evidence, and it will make that publicly available for us to investigate. I do believe it's unlikely at this stage that we're going to have anything other than a rigorous investigation. And that's precisely as you said, Benny, because people kept pushing for this.
Yes.
And that's why we're going to get the transparency that we need, because the public interest element is there and it's active and it's been pushed so much in this case. So now
We
we've.
have,
Oh, we had another one, didn't we? Oh, sorry.
yeah, where is my colleague and has she not stepped forward as a witness? From my understanding and from my research, she actually has, and so has another security guard who also works for the same employer as Belly Mujinga. However, upon reviewing the CCTV footage, the British Transport Police saw that, claimed that, that there was no spitting or coughing happening in that on that particular day. There was no assault, therefore. So she has stepped forward. She has said that, she also got COVID-19, but yeah, she has said that you can really say.
And so when it comes to the decision that they would make in terms of the evidence, the CCTV footage would be a massive factor. But if they, so the point at which the witnesses would be um, even more important would be if the CCTV evidence is found to not show spitting, but also not show spitting. So if the CCTV evidence itself is inconclusive, then that's probably when we're going to see the CPS reviewing or relying upon the witness evidence and trying to assess the witness evidence. Now, this is the point at which prosecution decisions matter, because if it's the case that the witness evidence isn't strong enough and they did bring a conviction, or they did bring forward a prosecution in this case, the defense for the man accused of spitting will very early on make it known to the judge or to the court that they don't believe that the evidence is sufficient to bring a prosecution, and that's why they can't bring a prosecution they don't believe they're going to be able to actually be successful with, because if they bring it and it's not strong, the case will be, you're not going to have a full hearing. The case will be dismissed. Um,
Immediately.
and that's not what you want. And I think that would be more demoralizing than actually not having a prosecution at all. But what do you think? Do you think that's unfair for me to say?
No, I don't think at all it's unfair to say, because even the CPS, they have to consider the ground rules of, they can't waste time, they have to use the court time fairly. And if the defense immediately attacks and says, listen, can you prove the assault? Did the assault really happen? What's the point of taking it to court?
we need we need more evidence. And I thought, okay, so because these things are quite relevant and related, why don't we talk about
Mhm.
the issue of causation? Because whether it is that, no, actually, before we do that, let's discuss
Yeah.
homicide.
Yes,
Let's
yes, because
discuss
I've seen a lot
homicide.
of people say, oh, he should be charged with murder, he's killed her. And I completely sympathize and I understand why people say that. However, the legal test for murder doesn't just work like that. We can't just say because he did that, she caught that, and now she's dead. It doesn't quite work like that. In murder, we have to consider this thing we call mens rea, which is called intention. Did the suspect or did the man have the intention to kill her or cause her any grievous bodily harm? And coronavirus or COVID-19, as it is already a deadly disease, infection, sorry. So, how do we prove that this individual had the intention of killing her or causing her any grievous bodily harm? That's the issue as to why murder is likely to be ruled out.
And that's exactly correct. And that similarly feeds into causation in the terms of the civil case. Now, when it comes to proving the employer was negligent uh, to the extent that they caused her death, the question that's going to be asked is, did what the employer do to fail her result in her death? Um, and what's really interesting about civil law is that the balance of, so the burden of proof in civil and criminal are slightly different. Now, the burden of proof is what has to be proved, and to what level does it have to be proved in order for the court to find a particular result. In crime, I know you're probably used to hearing beyond a reasonable doubt. The standard now is that to the extent that the jury is sure. Now, sure is a
Yeah,
very,
yeah, set it and break it
it's
down.
a new way of saying the same thing,
Say
kind of.
beyond reasonable doubt.
And therefore, in civil, it's slightly different. It's the balance of probabilities, so it's more likely than not. So 51% or higher. So what would have to be proved in a civil case is that it's at least 51% likely that Mrs. Bajinga died because her employer failed to provide her with PPE, failed to allow her to work off the concourse, and failed to permit her to use her private PPE. Um, I think even though questions could be asked about, well, she was working on the railway, she could have got it from everywhere. I think if there was a civil action brought against the employer, then it would center around that. Can the judge, is the judge at least 51% sure that it's, 51% sure that that's more likely the reason she died than
Yeah,
anything else? Which brings the case into a slightly different place. It means that things that may not be as helpful in a criminal prosecution may actually be helpful. For example, if you've got two
mm,
witnesses saying there was a spitting attack, we were there, that's more likely to be the case that there was one. But if you've got a video that doesn't show spitting, and you've got two witnesses that say they did see spitting, you may have
handcuff.
the witnesses, but the video could cancel out the witness evidence, and now the 51% may not be made out. Maybe now it's only 40%. So this is the logic that will be applied in a civil context and the logic that will be applied in a criminal context. And that is why, without having that evidence in front of us and actually seeing what they're seeing, it's hard to know what would happen. But know that either way, these are the standards that are going to be applied.
Yes.
And that murder, so finding intention murder is very unlikely. And it's more likely, if there was to be anything, that there would be a manslaughter charge.
Yes.
Um, thank
But
you.
even with that, we're scratching the surface. I think we have a couple of questions, We
I
had like
think we
two.
did.
Wait, there was one. Sorry, no, two. So, someone said I thought it was her and another colleague.
Who were on the concourse?
Yes,
Yeah. So you said in your research you found that they both contracted coronavirus.
coronavirus, and then someone mentioned contributory negligence.
So contributing negligence would only be relevant if, let's say, the employer made her work on the concourse but provided her with PPE and she refused to wear it. In that case, the employer would still be found negligent, but then they would sort of offset some of the blame or the damages they have to pay by saying you contributed to the harm. But in this case, they couldn't say that because she
Oh,
actively tried to do the opposite. So they're not going to be able to make a contributory negligence claim.
oh,
Um,
that's a question. Saying, how long do you think until we hear back from the CPS after they have reviewed?
um, I don't know timescale
I don't
wise.
know time scale wise how long they can take. From my understanding, they can take as long as they want, as long as they need to, because there is a lot of public interest on this case at the moment. So I don't think they're just going to rush past it and call it a day. So I feel
Mm.
like they're going to take reasonable time to make their own investigation and to come to their own reasonable conclusion. So who knows? Maybe the end of the month or next month, but don't quote me because I believe that they will take reasonable time
They'll
to.
take a reasonable amount of time because, again, a failure to take a reasonable amount of time, a failure to properly investigate, again, could be the subject of a later challenge.
Yes.
I was wondering, now I'm going to quickly look this up, but I was wondering if
Mm-hmm.
we quickly look at the role of the Attorney General and the CPS, because it
Sure. I
has
think
been
I
known.
mentioned. Twitter. Did you see that?
Pardon?
I think somebody mentioned him on Twitter
Mm.
literally the other day and their role in bringing the investigation forward.
Yeah.
But yeah,
So
that's
the Attorney General, so the Office of the Attorney General supports the Attorney General and the Solicitor General, the law officers, and they are government ministers. And one of the roles that they play is superintending or overseeing the main independent prosecution department, the Crown Prosecution Service, and the Serious Fraud Office, and perform other functions in the public interest, such as looking at sentences which may be too low, and and they do things like that. So
hmm
it is possible if say for example they do find a prosecution and then there's a very low or very lenient charge given,
hmm
they could someone anyone can ask the attorney general to examine the sentence within 28
Just
days of
put on to
sentencing.
the point on lenient sentence because I have a case or two regarding lenient sentencing as well, which actually quite relates to the Billy Mujinga case.
Yep.
So, yeah. So then there's a question: what would be the role of the DPP in this case?
um Let me try and see
Yeah, what
whether
I was.
there's any precedents, whether there's any precedents for um
Role.
now I all of the so I had it I was looking up because all of the there was a tweet very specifically referencing Max Hill. um
Yes, because he's the appointed DPP on this case. And to answer your question, Baroness Raphael, the DPP's role would be to decide whether or not to charge for committing the crime. So it's whether to decide to prosecute the individual who spat and coughed at Billy Mujinga.
and it's I'm sure I saw it. Yes, okay, so this is the I want to read this thread to everyone. This
Mm-hmm.
thread is from Matthew Ryder QC, who is a barrister, and he basically broke down in a very quick thread. So he said, and this thread was about the review of the evidence, and he said this is a powerful example of activism and protest working. A few days ago, those organising the Black Lives Matter march in London were determined to make sure everyone focused on Ms. Belly Mujinga, who died after being spat at during her work. Police had closed the case last week and protesters wanted it reopened. As well as protests, over 1 million people signed a petition to that effect online. Today, the CPS announced it will look at the matter and review the evidence. Credit should be given to the Director of Public Proceedings, Director of Public Prosecutions, Max Hill QC, for his role in understanding why it was important. And this is possibly where the role of the DPP is going to be very important, because he is essentially the driving force behind why it was it was understood that the evidence needs to be gone through with a fine-tooth comb. I think it's important to acknowledge that, because if we didn't have that internal lobbying, we may not be here where we're even discussing.
Actually, I don't think we would be because my research actually showed that once Miss Mujinga died, her employer sent their condolences, which people have described as crocodile tears, and that her union actually let her down, and they didn't even acknowledge her death until people questioned them to say, "Did you know that a member of your union has passed away?" So,
And that's the example we talked about how when we're talking about Black Lives Matter and the entire movement, and black women being failed and black men being failed,
mm,
it's beyond not bringing a prosecution. It's beyond that, and
it's
it goes more into, at every stage, why was she not being fought for? Why was she not being prioritized? And
why was she
that's
not
when you
looked
start
at
asking
as a human
questions
being? It's
as a
the
human being.
question. Why did her employer just think she's a robot despite her saying, "Hey, listen, I've got breathing issues. Don't put me in that position." Why did they
Mm.
still say, why did they still force her out? Why did they still create? this unsafe working environment for her. So the CPS, I think, is going to do a good job in doing this.
Well, they have to, because there's been so much emphasis on getting this transparency for the public. And I think, and just to make a sort of tangential point, I think this is why it's very important that we continue to. Sorry, I'm just changing my camera. This is why I think it's very important that we continue to keep this energy going forward. Um,
Don't stop.
we can't stop. And one of the biggest reasons we can't stop is I want us to normalize having this kind of transparency
Yeah,
with prosecutions and policing. Do you know what I mean?
I understand.
I want this to be the new standard where they feel that they need to explain themselves and they feel like they need to do a thorough job, because they do. And it's not that the standard changes based on who the victim or the complainant is.
Because the BTP, they are transparent if you really think about it. Because there was a case, I think it was during the summer of 2019, where they were in the process of prosecuting or looking for a young lady who was involved in an assault. They released very clear pictures of the young lady who they were looking for, the date and the time, what she was wearing. Everything was out there. They were very transparent about who they were looking for and what they were looking for her. So from her. So expecting transparency from the BTP shouldn't be anything new, but it's
Mm.
just heartening to see that when it comes to Belly Mujinga, they're withholding the tape that we're all wanting to see. I understand they don't want to be involved in the court of public opinion, because public opinion will tell you, oh, maybe I saw this and maybe I saw that. That might confuse the case completely.
Mm.
But it is important that the tape is reviewed and that people understand, and the CPS sees that, hello, this woman was an individual, she was a human being who was let down by her employer, most importantly.
And that's why, again, this is why I'm glad that the emphasis is really being put on the power of protest, the power of all of us pushing hard
Mm,
and continuing to amplify. And this is the energy. I just want us to stay consistent with this energy, because that's when it makes it easier to make public interest arguments, because you can
yeah.
prove the public interest. So again, I want to encourage everyone to please continue to jump in with your questions. Now,
Mm-hmm.
we wanted to also discuss corporate manslaughter. Now, I found this as a general. So I've got a overview on corporate manslaughter, and so I was going to read that. We've got a question. Wasn't there a man claimed for having jail for claiming to have COVID-19 and coughing at someone? Yes, and I believe that was in Scotland. Was that in Scotland?
That was in Scotland, and there was also, I think, a case in London where a young man pretended to have COVID-19 or coughed at a policeman, and he was dealt with through the court. But I think we should get into that. I will focus more on that question a bit more because I've got some other things with that involved as well. So please bear with so we can talk about the manslaughter, since we can't go through murder route.
Yes. And so I'll quickly talk about corporate manslaughter as a potential thing, just to put everyone on the radar that this could possibly be something. So, corporate manslaughter, I'm going to quickly give you an overview of what it is, and, just break it down. So, I just want to give you a definition of it.
Mm-hmm.
I'm trying to find a definition that's not dry. But this is law.
There's nothing fancy about it.
So corporate manslaughter is a statutory offence, and it's contained in the Corporate Manslaughter and Corporate Homicide Act of 2007, and it also references the Health and Safety at Work Act 1974, which you highlighted in your research, Beni. And also, if anybody is really interested in actually seeing Beni's research and actually wanting to get evidence and resources that we've used to plan, please send either herself or myself a direct message, and then we can see about getting that to you if you want to have that. So the offence reads as follows. Once my internet loads. An organization to which this section applies is guilty of an offense if the way in which its activities are managed or organized causes a person's death and amounts to a gross breach of a relevant duty of care owed by the organization to the deceased. The organizations to which this section applies are a corporation, a department or other body listed in Schedule 1, so they've listed a bunch of people, a police force, a partnership, a trade union or employers association that is an employer, an organization guilty of an offense under this section is guilty of an offense under this section only if the way in which its activities are managed or organized by its senior management is a substantial element of the breach referred to in subsection 1. For the purposes of its act, they've defined what relevant duty of care means, and they've also said a breach of duty of care by an organization is a gross breach if the conduct alleged to amount to a breach of that duty falls far below what can reasonably be expected of the organization in the circumstances. And they've defined senior management, and an organization that is guilty of corporate manslaughter or corporate homicide is liable on conviction on indictment to a fine. And the offense of corporate homicide is indictable only in the High Court of Justiciary. So it's a very, so I wanted to give you that definition because this is a very unique and interesting area of law, and it's not very often prosecuted. So this overview was written by Stuart Ponting of Walker Morris and Mark Ballis of Crown Office Chambers, and I'm very sorry if I said his surname wrong. Contrary to popular belief, prosecuting authorities are not quick or keen to prosecute unless the evidence and public interest clearly supports such a proceeding. The decision to prosecute is taken by the CPS, and the decision must be made in accordance with the Code for Crown Prosecutors and the Director of Public Prosecution's guidance on charging. Prosecutors also have access to publicly available legal guidance on corporate manslaughter prepared by the CPS. Cases that may result in proceedings for corporate manslaughter must be referred to the Special Crime Unit in the Special Crime and Counterterrorism Division of CPS headquarters so that an overview of all cases can be maintained. And then they've given some investigations.
So how do you simplify those terms? Because I don't think everybody quite understands the legal jargon. What's going on.
So now let's break it down. Okay, so essentially, in summary, if when the CPS looks at the evidence in the case, they may very well find that there isn't enough evidence to support an assault charge, for example, against the man who allegedly spat. But they may find that the actual working practices of Mrs. Mujinga's employer was so dangerous and so negligent to the point that they caused her death or contributed substantially to her death. At that point, the CPS could very well raise a unique and rare prosecution, which is called corporate manslaughter, where they say it's not the individual civilian that caused her death, but it is this organization of people that caused her death. And I think that would be a very, very powerful thing for them to do, especially given this public interest element that they've already so clearly recognized.
But don't you feel that at the moment the public is more interested in the individual who cuffed and spat at her?
Yes.
So I feel like that's where the question of constructive manslaughter can be considered, don't you think?
Yes, and I think this is an interesting question that I will be interested to see anybody who is active on like legal Twitter or the lawyers involved who have a familiarity in these kinds of cases. Maybe somebody with prosecuting experience could explain and actually clarify, do we think that this is something that we should be focusing our energy on? Because I'm sure you agree, Ben, there doesn't seem to have been as much heat towards the employer in this case so far.
At all. There has been, from my understanding, the investigation has been mainly focused and centered on the individual and their antibody tests. But we haven't even looked at the avenue of prosecuting the employer who put her in this situation. So that's a good avenue to look at. But for my research, because I was mainly heavily focused on the criminal, I looked at constructive manslaughter. And I don't know how popular that's going to be with people because everybody was the champion of charging him with murder.
Mm.
But manslaughter is made out that the offender must commit a criminal offense. That offense must be objectively dangerous and it must cause death. Now, let me break that down so people can understand what this means. So that means that the suspect has transmitted or threatened to transmit COVID-19 by coughing or spitting at Mrs. Mujinga. Usually, the spitting and the coughing alone could and would amount to a criminal offense. So the law is very, very straightforward on don't spit at people, it's an offense. Especially in this COVID climate, don't do that. We're gonna come for you. Now, when it comes to threatening someone with harm and assault, or to apply force by, you believe it or not, spitting at someone is
Mm.
considered applying force. Now, some people might say, well, that's battery, isn't it? And it is. But since the suspect, for my research, I've understood that the individual, he actually declared that he had COVID-19.
Mm.
So then the attack, because of that declaration alone, that attack now amounts to assault. So if Mrs. Mujinga perceived the harm alone, just the harm, even if you just think that, oh my God, he has COVID-19, I'm in trouble, that alone would amount to assault.
And I'm
Okay?
glad that you clarified that.
Well, pardon?
I said it's good that you clarified that.
Okay, thank you. And then the third point is that the offender must have either intended or risked that Miss Mujinga will feel threatened or that force will be applied. Now, that's where I feel like it's going to get rather tricky because,
Mm.
again, intention is a difficult thing to prove in court. How do we prove beyond reasonable doubt that this individual intended or even risked that Miss Mujinga will feel threatened, that he will apply force through coughing and spitting?
I
Or
think it could
what's your
be.
opinion?
I think it could be read into the act itself. You know, you do that because you would only do that if you wanted somebody to perceive that they could potentially catch coronavirus from you. That's what would
Mm.
lead you to make a statement like that. And I think that is that'll probably be what would be what would rest upon coming to find that harm element that you mentioned in the offense.
Yes.
I think
So
just in its nature.
yeah. So now the CPS, thankfully, has already prosecuted a number of cases which had similarities to Mrs. Mujinga's case. For example, an individual has already been jailed for coughing and spitting at a Northwest emergency worker. And the assault carries a maximum sentence of 12 months in prison. Now, we're going to sound like a bunch of boomen because we don't want to hear that individual get 12 months for
Mm.
spitting and coughing at somebody, allegedly. Um, Now, the prosecution is also bringing in the aggravating features of this case, which is the aspect of coughing and spitting and threatening the victims with coronavirus to the court, and especially during the course of sentencing.
Mm.
So we can see that they're really, really coming down on people hard that do not assault our essential workers. So would they take into account that Ms. Mujinga was considered an emergency worker or a key worker, essential worker, even the term that they used?
I think they would. And before I answer that, I'm just gonna say that I'm gonna answer your question and then we'll wrap up because we've got one
Mhm.
minute remaining. And then we're still
Okay.
gonna be continuing to go live on YouTube, but we'll just restart this live and just sort of do a part two and just talk and then take people's questions. But in summary, I do think that they will take into account the fact that she was an essential worker. I think that they have to because of the emphasis that's been placed on how important that people like Mrs. Mujinga are. And we're going to discuss more of that. So thank you everyone who is tuned into this live stream. This is now going to be part one.
Mm.
Please stick around, don't go anywhere, and stay on Instagram and join us for part two. And we'll still be live on YouTube. So hello, if you're watching on YouTube, we're still here. Okay, so see you on Instagram in just like a couple of minutes. And if you're on YouTube, we're still going. Okay.
But
I have to end it. So, bro, it won't even let me. I have to. Higher. It won't let me download the video anymore.
come back. Wait. Oh,
Instagram is really wilding.
I was gonna be. Come back. Where are you?
No, I'm saying Instagram is just not very intuitive. It's very I
Oh,
really want to use Instagram, like don't get me wrong. I really want to, but they make it so hard.
it's so tricky.
Um just typing with one hand.
Uh-huh.
um no, but it's good to see that in those other cases that they did actually um take into account the harm element in relation to coronavirus.
Mm-hmm.
Uh,
Definitely. And I appreciate a lot that they actually saw essential workers as human beings that needed to be protected, you
big,
know?
big facts. Okay, so I'm just gonna. I can't believe Instagram shagged me and didn't let me download the video, but it's okay because I found a
We're gonna find it.
I've genuinely found a hack to get your Instagram to what like to use. I found extra tools that I use now. Right.
Whilst you do that, I'm just gonna like load up my phone again so we move for part two.
Yeah, load up your phone. So I just wanted to. I hope people join us on YouTube, but then this video is going to be here forever. So YouTube people, you're going to have this video. Okay,
Forever.
so we've got case update part one, and now
Hmm.
we're going
We
to
go for case update two.
we go for number two. Okay, let's do this.
Just give me one sec.
I'm going live again. Hello everyone. We're going live on Instagram for part two of the Belly Mujinga case update. Just give you a moment to join us. And YouTube people watching this at some point in the future, thanks for staying with us. Um, okay, so just gonna double check the YouTube live stream, make sure all is proceeding as it should.
Mm-hmm.
Thank you everyone for rejoining us on Instagram.
Oh wait, let me just rejoin you now.
Everyone for rejoining us on Instagram.
Okay, I can see you.
I'm muting my laptop now.
Yeah, wait, me too.
Right. Hello. So please continue to ask me questions on Instagram. I'm just going to add. Hello. So please continue to ask me questions. I forgot to tell Blessing at the bar that we're live. Instagram. I'm just going to.
And we're back.
We're back. Hi.
Hello.
So just to pick up on where we left off, I do think that it's going to be relevant in light of these other cases that you've mentioned. I do think they're coming down very hard on people, even if you're pretending to have coronavirus. Like it's foul and it's criminal.
Very foul. Yes.
So
let me just send the link again. Sorry, bear with me.
No worries.
Ooh.
So please, everyone, because we really are keen and here to answer questions from you. So please just feel free and don't be shy about asking us questions and giving us an opportunity to respond to them. We really want to do that. So please jump in with your questions. So I'm just going to go back to our research and just basically see what more that we want to discuss. I think I just wanted to make a more general point, really, and discuss this with you about why do you think that, because to me it's just not a coincidence. Like, when you look at things like outcomes for Black people in the criminal justice system, outcomes for Black women or Black people when they interact with the healthcare system, outcomes for Black people in employment. I think what I really hope that these cases and discussion of these cases really normalize for people is that same human empathy isn't actually always shown when the individual, the victim, the complainant is black. And that is a
Exactly.
problem.
And
Like, that is
especially
a
when it's black
problem.
women, because we're seen as if we're robots, like we can do or can do or attitude, but that's not the case. We are human beings. There is this metric of, strong black women, but we are human beings. We're vulnerable just like everybody else. And we saw in Miss Mujinga's case, people are starting to realize the strong black woman thing, it doesn't work. She's a human being. Because if she was the strong black woman, why did she pass? Just goes to show she's a human being. She had weaknesses and she needed to be protected. And the people who should have protected her did not do that.
They didn't. And that strong black woman trope, the thing that affects and impacts people,
Mm-hmm.
is that idea of you're just never supposed to say anything. And this heartbreaking
Mm-hmm.
thing is that you can say something and then it's completely ignored. Um,
Completely.
and that is the struggle. That is the hard part, the hurdle to overcome. So I was just wondering, is there anything else that um you wanted to discuss or bring up about the case? Because we haven't had a lot of questions so far in the second part. Again, please guys,
And
if
the
you don't
second
have questions, we're just gonna wrap up. So if you still want to.
um, I still wanted to explore the issues arising with exploring the manslaughter route,
Mm,
because should CPS, for example, go into charging him with manslaughter, there are issues arising with it. It's not straightforward. In
mm.
fact, they would need to establish beyond reasonable doubt that there is a causation. In other words, there's a link between the criminal act and the death of Miss Mujinga. And then the real hurdle then will be conviction. Because how do we convict someone of infecting somebody else with coronavirus if COVID-19 is easily contracted?
Yeah, so how do we prove
How
it
do
was
we
that
go about
specific
that?
incident? Yes.
So then the prosecution would have the hard job of then proving that COVID-19 was contracted, sorry, from that particular person and not just from any random person she came in contact with during the course of her day. And then they will also then have to consider that this woman had respiratory issues, and thankfully that aspect is covered because criminal law actually has a test called the Thin Skull test, which is basically taking your victim as you find them. Correct me if I'm wrong.
Hmm.
So in Mrs. Mujinga's case, so my research, the CPA says could, and the key word here is could, consider manslaughter rather than murder, because, like I said earlier, murder requires intention to kill or cause serious bodily harm, whereas with manslaughter, intention is not required. So,
And
I hope that clears up the murder plea.
and this is the thing that is important to reference when it comes to the eggshell rule is that um if what the point of having that legal principle, whether it's in a context of finding negligence or a context of establishing a criminal offense, it doesn't matter if your victim was particularly frail or your victim had particular health issues and you want to say, oh, but what I did wasn't so bad, it wouldn't have killed anyone else. It's like, that's not the point. You take your victim as you find them, and that's
Fine.
it. If you cause their death, you cause their death. And I think that it's important that we remember that, because it's never going to be the case that you can say, oh, they didn't have, well, how was I supposed to know that she had respiratory issues? I only spat at her because, like, no, you can't
For
do
the
that.
fun of it, I puffed on her because I thought I'd scare her a little bit. No,
Yeah,
the
it
fact
doesn't,
that
it
he found her,
literally doesn't matter. People don't have to
the
carry
fact that
around
he
a
found her
sign.
like that. Yeah.
Yeah, so, um, no, I'm glad that you addressed that. And I was just wondering, does anyone have any questions? Again, please jump in with your questions. Otherwise, we're just going to chat between us until we cover everything we want to cover. I would be
Mhm.
really interested. Like, I want to return to this corporate manslaughter case. Um,
Yeah.
I want to look at the public interest test. Um, So when it comes to corporate manslaughter, this note that I found, if we were, so just for everyone tuning in who's maybe not familiar with what we're talking about, we're referring here to the offense that can be brought by the CPS if it's believed that an organization, so a corporation, or like a trade union acting as an employer, basically was the management or the senior management decisions and the corporate culture, the working environment they created, was it such that it resulted in someone's death? And the
Mm.
reason that we've raised that is because it's known in the case of Mrs. Mujinga that her employer did not provide PPE equipment and insisted upon having
Yeah.
her work on the concourse, on the front line, in front of the public, despite her having respiratory issues and despite her asking to work in the back office. Now, that is why we're discussing this. A big point to make is that this kind of prosecution is extremely rare. It very rarely happens.
Very
Um,
rare.
and one of the biggest things in it is the public interest element. And what they would look at is how serious was the offense? What was the harm committed to the victim? What is the impact on the community? And is the prosecution a proportionate response? It would be an unusual conclusion for the CPS to decide proceedings for corporate manslaughter were not in the public interest. Um, and so that part I thought was interesting, especially impact on the community. This has a massive impact
Impact
on the
on the
community.
community. Huge.
So,
People are protesting up to this very day. I can hear outside that it's raining. So you can see that Beni Mujinga's case had a massive impact on the community. Huge impact. So it would be unfair to say that the CPS does not recognize that because evidently they do. That's why we're here, able to discuss that. They are reviewing the evidence.
and yeah, and that, so yeah, so I wanted to address that. So thank you for that. And I've also found something on CPS approach in practice. Um, so prosecution of senior managers for gross negligence, manslaughter, and health and safety offences have historically been rare. Um, the Health and Safety Offences Act 2008 has provided the courts with the ability to impose custodial sentences of 2 years imprisonment for employees and directors convicted of safety offences. This expression of parliamentary intent has been combined with a far greater emphasis upon individual accountability in terms of corporate harm. The number of individual directors being prosecuted under the Health and Safety at Work Act is increasing, as too are those prosecuted for gross negligence manslaughter. In looking at an organization's potential corporate manslaughter liability, the spotlight is being focused on directors, with the police and CPS being required to consider the position of such individuals at a senior level in the company. The prosecution of individuals would see the same decision to prosecute considerations apply under the code. So essentially, what they're looking at here is what's being said is they are increasing generally the amount of people they're willing to convict for causing death because of being grossly negligent. And they're also,
Yeah.
when they're looking at a corporation, an organization, they're looking at the directors of the organization and how much influence they had over how the organization was run. And I think it would be interesting, evidence wise and evidentially, to actually see, was there a top down culture of not permitting anyone on the concourse to use private PPE? Or was it a lower
Was
level
it an
decision?
because my research revealed that it was actually a decision that the manager told her she wasn't allowed. The manager made her go back outside and work. So how the question then arises, do we prosecute the manager or do we go to the corporation and say this is your fault?
And it also depends on whether, so that manager, let's say, for example, they were supplied with instructions to not permit anyone to work in the back and not make exceptions. I think then it would push further up the chain.
Mm-hmm.
And employer negligence covers the negligence of employees as well. So if a manager acts in a negligent way, it would still capture the employer. So this is the interesting element. To what extent was this a management decision, and to what extent was this
And was it the managerial? Sorry,
Yeah,
the corporation.
like wider.
So that would need to be definitely looked into by the CPS, I believe. The
Definitely.
CPS might have to review that, but for the moment, they did say they were just going to review the evidence they had at hand. We don't know for a fact everything what they have at hand because that hasn't been released to us, the public.
They could have things that we don't know about.
Exactly. So those things have all to be considered. But yeah, but how do you think the CPS is going to react to this? What their decision is going to be?
In relation to the original investigation or corporate manslaughter?
Both.
Okay, so for corporate manslaughter, I found something interesting on the actual cases that the CPS has decided to bring. And it says, so far, the cases reaching court have involved companies which are relatively small and owner managed. There's a further similarity in that the pattern is emerging of additionally charging the organizations with health and safety offenses and of directors themselves being charged with both gross negligence manslaughter and health and safety offenses.
Mm-hmm.
And they've given the case of R and Line Steel Equipment Limited unreported. So it's like an unreported case that they've just referenced themselves. And I'm just gonna
Uh-huh.
try and pull it open so I can quickly get an idea. So this corporation pled guilty, and this was what
Yes.
happened.
Mm-hmm.
So the defendant, Lion Steel, has pleaded guilty to the offence of corporate manslaughter arising out of the death of its employee on the 29th of May 2008 at the factory premises of the defendant. The employee fell some 13 meters to his death through a skylight on a roof, onto which roof he had gone to repair a leak. Um, and so that was the reason. So this guy fell through a skylight and then died.
Ooh.
And so the indictment that was brought against them by the CPS said essentially that according to the Corporate Manslaughter and Corporate Homicide Act of 2007, they
Mm-hmm.
caused his death in that they failed to ensure that a safe system of work was in place in respect of work undertaken at roof height, which in failure amounted to a gross breach of a relevant duty of care owed by the organization to the deceased.
Mm-hmm.
Then they brought a second count of alleged manslaughter against all three directors of the company. And the Crown Prosecution said each was under a personal duty of care towards the employee, and he died as a result of what the Crown say was their gross negligence, or to put it another way, the gross breach of duty of care the Crown asserted was owed to them as directors to him as an employee. So essentially, in this case, what they found, without going too far into it, because I've just had a look, but essentially, because the employer hadn't put enough safety measures for when someone was specifically working on the roof,
Mm-hmm.
and then he died a result of completing that work on the roof, it was sufficient to sustain a charge of corporate manslaughter because
Gotcha.
their action has resulted in his death. Their failure to provide a safe work environment resulted in his death. I think it's interesting, just to wrap up on corporate manslaughter, I think it's
Yeah.
interesting to see how often these cases involve smaller companies, because then I think it's easier to track the decision,
To
right?
track who did what and what went wrong.
So I wonder
But
whether in this case it's worth people making a noise about corporate manslaughter and actually making noise about having this looked into properly. I think it's worth making noise.
I think it's
What
definitely
do you
worth
think?
looking into Govia Thames Link railway and see what went wrong, who said what, and why did she get to that point? Because if you look at the law on this, really this could have been all avoided.
Yeah. It's the but
This
for
could have
element, isn't it?
the but for element, but for her working on frontline, but for her being spat and cuffed at, would she have passed away?
And this is
So
the
potentially, do you think potentially we have two defendants in here? The corporation, her employer, and the suspect or the individual, sorry, who spat and coughed at her on that day.
yeah, I think these are probably the two biggest like individuals or entities that are involved. I think whatever the CPS does, these are the two people they're going to be looking at the closest. These are the two people
Yes.
that they're going to pay the most attention to.
Hmm.
And when I say people, I mean a legal person. You know, a company is a legal person.
The
So that's
company,
that's what I
Godia's
mean when I say
Exchange
people.
Link, and the suspect. We don't know his name, unfortunately, so we can't really say his name.
Um, yeah. So I think I really feel. You tell me. I feel really strongly that people should be making noise about getting the CPS at least, even if they don't bring a charge of corporate manslaughter. But tell us why. I want them to release an opinion on this.
I want them to release a full-on report on how they conducted their research into Billy Mujinga's case and how they came to whatever conclusion they will come to. If they don't pursue the corporate manslaughter, why can it not be manslaughter? Why can it not be assault? I understand that people will not be satisfied if they hear he's been charged with assault, because looking at the case law,
Mm,
some people got 12 weeks suspended, some people got 12 months suspended, some people got a custodial sentence, meaning they went to prison.
that's
Are we
discretion.
the people, are people going to be satisfied with hearing that Billy Mujinga's assaulter went to jail for 12 months and got out? Would we be satisfied with that? I believe the answer will be no.
And I think
But the court, sorry, so the court, they might consider that justice has been served.
exactly they may think that there's nothing further to look at. They'll say, based on this, based on the evidence, and this is where it gets hard, right? Because at
Mm.
some point this would go down to the discretion of a court on the evidence or the discretion of a
Mm-hmm.
judge on the evidence. But
Yes.
I'm really pro corporate manslaughter in terms of that should be something that's explored. I mean, from what I've seen and what I've researched on corporate manslaughter, it can be done. However, now this is a really interesting vulnerability. We've talked about judicial review in the case of challenging the
Yes, I was
CPS's
just about to mention
decision.
that.
But if the CPS brings a charge of corporate manslaughter, it's very possible that they themselves could be judicially reviewed for bringing that prosecution. Um, and it's interesting that the courts. So it says in practice, the courts will
Yes.
disturb the decision of an independent public prosecutor only in highly exceptional cases. So there is a possibility that they could bring a corporate manslaughter charge and somebody actually intervene and say, no, that's a misuse of your power to bring that charge,
That's a misuse of your power. Don't use that charge.
which would
That is also
probably.
another.
No, carry on.
Sorry, go on.
You go.
Which will probably be a cause of a lot of contention if they were to go down that particular route. But no, anyways, carry on.
So I just wanted to say that generally, from what I've seen on this overview of the case law, there is a tendency for people to just plead guilty to the offense, usually because the evidence is so overwhelming that it's
Yeah,
better that they make a
guilty.
plea, and then you can sort of reduce what the actual punishment you're going to get.
By one third.
Yeah. So if you do want to challenge it, one avenue would be via judicial review, and I wouldn't be surprised if there was, unless the CPS were to produce an ironclad reasoning, I wouldn't be surprised if they did find themselves under challenge for actually bringing this prosecution, were they to bring one. And yeah, so generally that's kind of what I'm feeling. I feel quite strongly about looking at corporate manslaughter.
Corporate
Um,
manslaughter, right?
and what I find, just because I think the causation thing is something we really wanted to explain as well. But what I found interesting is here it says the usual principles of causation in criminal law apply in corporate manslaughter, so that
Yes.
management failure need not be the sole cause of death. It need only be a cause. The principle of novus actus interveniens can apply, but seldom does. So, what I wanted to clarify here, and for everyone that was with me when I previously said novus actus interveniens in a previous live, I hope you were listening at Blessing School of Law. But basically, when it comes to causation, you have A and you have B. So A is the action, B is the resulting event. So let's take her employer providing an unsafe work environment, her contracting coronavirus and dying. That's A, that's B. What's being said is that where you're bringing a charge of corporate manslaughter and it's relevant that A happened, i.e., A is the corporation failing to provide a safe environment and B is the death. What isn't common is that the employer can argue and say, oh, but after she left that day, she went on the bus. Oh, but after she left that day, she went on the
She
train.
got on the train.
Someone else could have given her coronavirus. It's
Or
merely
she
that
went
it's a
home and somebody
cause.
else got it.
Yeah, so it's merely that it's a cause of the death. And I think that is where most of the argument would lie on, well,
Yeah.
did we really cause your death by not, did we contribute to your death? Like, how could it be so? And I personally feel, just on my personal view, I think
Mm-hmm.
that that argument couldn't possibly be made given
It
what
wouldn't
has
hold
now been
itself.
demanded of us when we use public transportation.
Exactly. And considering that whether we like it or not, COVID-19 is deadly. So how do we say she died because of this individual or this corporation? The argument could also arise that she could have caught it anywhere.
Anywhere, yeah, she
She
could have got it here, there, and
anywhere. How
yeah,
do we prove that it's because of them?
and that will be
It's
the heavy emphasis, right? Why
the
did I do
defense
this?
would be very hard on that. But
Um,
I don't know. I don't think. I mean, the cop out. I mean, would be potentially looking at just assault. You know, he assaulted her. Goodbye. But then BTP said in those tapes they saw no coughing and no spitting. I don't know if BTP wanted to see. Do you know when people like do those spittings that comes from the throat and then it goes out and then maybe they wanted to see that. I don't know, or maybe he spat next to her. I don't know what they expected to see because I haven't seen the tapes. But how do we prove that? It's just how do we prove that beyond reasonable doubt, and to avoid getting an appeal 2-3 years later saying you didn't prove that he did that.
yeah,
How do we avoid that?
you want to avoid an appeal. You want your prosecutions to be ironclad. And this is why I'm saying I just hope, in my view, that the CPS produces the report like a full report of their findings. And yeah, that's really what I would be wanting to see. So have we discussed fully causation in terms of, yes, we have. We've explained the
Yes,
different elements of it. So really, unless people have any questions, what's left for us to discuss today?
sentencing, maybe push over the pot of sentencing. Maybe people, with murder we understand that there's a life tariff to it, there's a life tariff attached to it, but we've been throwing out manslaughter and assault. How much time could this corporation potentially get, or how much time could this individually potentially get if he's charged with assault, convicted of assault or constructive manslaughter? It was relatively tricky for my research to establish with constructive manslaughter how much. I knew the maximum. I understood the maximum was 24 years, if I'm not
Mm-hmm.
mistaken. From the sentencing guidelines, I saw 24 years. But if you consider things like, for example, he goes to court and he says, "Well, do you know what? I'm guilty." Then the judge will be like, "Oh, here we go, mitigating factor, 1/3 off." So we don't know how much they could have potentially given him. There could have been like, okay, here's 10 years or something. They've knocked out 1/3 of that 10 years and then consider people behaving well in prison. That's half time off as well. So then the question really arises, will there be justice for Billy Mujinga in the criminal court system or in the civil court system?
I again, without the evidence, it's hard for me to say. But
It is, isn't it?
I do feel that civil remedies, whatever civil remedy, I don't know whether people would feel. I wonder whether people would feel that it's just enough.
Mm, mm. Considering that a life has been lost, the community is affected, no matter what the court will give now, would just not be satisfactory enough to, help people, satisfy people at all. And even considering the assault charges, well, there's a question. Probably a silly question. No question is ever silly.
Never a silly
But
question.
would vicarious liability apply to the manager? I'll throw that to you. I'm not a civil expert. I'm
So
criminal.
the vicarious liability would apply to the employer. So if you just stay with me here, the manager does something. The employer is vicariously liable for the actions of any of its employees. So what happens in a lot of these cases, for example, questions of vicarious liability arise where somebody is on duty and then they commit an assault. And so let's say I'm working for Sainsbury's, I'm just working, I'm on my shift, and then I start beating the crap out of somebody. Is Sainsbury's liable for the injuries afflicted upon that person? Um, no, because Sainsbury's, none of my job description with Sainsbury's was beating people up or using force or restraining people. Similarly, where you've had things where nightclub bouncers have beat people up, it's in their job to use a certain amount of like force or to make contact with people. So then the question goes, well, did they go so far beyond their job description when they did that? So you can understand, if you can follow me, those are the kinds of questions that would be asked. Now, with the manager refusing to allow Belly Mujinga to wear PPE, refusing to allow Belly Mujinga to work in the back office, is that sufficiently connected to their job? I would say it is, because their job
Mm,
is overseeing personnel, deciding what personnel are going to do, where they're going to be. In relation to coronavirus, it was organizing personnel in the context of coronavirus. So if the manager negligently did that and failed to do that properly, then the employer, I wouldn't see why they wouldn't be found vicariously liable for their negligence. So whenever I've talked about employer negligence in this live stream, in the previous one and in this one, it's within the context of that manager is the employer.
yes,
Therefore, the person that you sue on the court documents isn't necessarily the manager, but
the manager.
they're
It'll be
vicariously liable
Goja,
for their
Goja
manager.
counseling. All right.
Yes. So I hope that answers your question, Laura. And if it doesn't, please ask me another one. Everyone else, if you have questions, please don't hesitate. Don't wait. Jump in. Ask us your questions. We love answering them. Otherwise, we're gonna wrap up and
Yes.
say bye bye. So I was thinking before we close up today, what I
Mm-hmm.
think would be good is maybe going through some of the arguments. I mean, there's not many, but maybe going through some of the arguments that could be made on the employer side. What's likely to be said in order for them to say that their work practices weren't so bad that they caused her death. Um, I struggle with
Ooh.
that because personally, for me,
I'm just thinking, do you know, from a human perspective, I'm thinking you can't defend that. But if I put my barrister cap on, a defense can be found because they could have said, well, she didn't have to come in.
we didn't
She,
ask her.
how
We
do
didn't
we,
make
how,
her.
we didn't make her come in. When she was assaulted, why didn't she immediately report it, call the police, and go home or go to a doctor and check if she had contracted anything?
Mm.
So there are a handful of arguments that can come up. For example, they can say, well, we were not responsible. Part of the job description is not. Oh gosh, I've just forgot my train of thought. Part of the job description is to be at the concourse, and she probably understood that there will be a reasonable amount of dangers coming up, like assault and violence and force being used, and perhaps she was aware of that and she agreed to do that.
So these are the kinds of things that they could bring up. I thought potentially also that maybe it could be said, God, I'm scrambling because I really don't know what they would
I'm
say. I'm
scrambling to tell.
scrambling. But maybe the employer could say that they didn't have sufficient or reliable guidance at the time to know that it was unsafe to not allow her to wear PPE. I
We
think,
have to consider it
or
happened.
they couldn't get PPE because this was at a time where the government itself wasn't giving PPE to essential
We were
workers in the
still
NHS.
in the moment where Boris Johnson declared we were in herd immunity. So when her situation happened, we were not in lockdown yet, and we were still under herd immunity, and we were being told just wash your hands for 20 seconds. You'll be all right. Like, 20 seconds, make sure you wash your hands, and you're good. But we just knew about these things after the fact. So that will also need to be considered. Like, at the time, the employer can't be blamed because we didn't know how bad COVID-19 is going to be. We didn't think it was going to affect her because we weren't even socially distancing at that point yet.
And what I would demand if I was counsel for the Mujinga family, and if that argument was made, I would demand all government circulars that were made available to transportation agencies,
Yes,
because I do believe that the public were being told just go outside and chill. But I do believe that employers were not being told the same thing. Like anyone working in a health industry or transport, I do
transport.
believe that they were being the danger was being communicated to them in a slightly different way. So I would
But that would
rebut
need to
that.
be looked into and fully analyzed. And then we would also need to look at dates. Dates would be so important to keep in mind, because I think as well what would be important is that, when was this individual tested? Sorry, I'm kind of venturing back into criminal. When
No,
was
but
he
true.
tested? When was he tested? And was that test accurate in comparison to the knowledge we have now
And this is
of the antibody tests?
questions to be asked, and I'm sure this is what the CPS has to look into. They have to, when they're looking at the evidence, they also look at the way in which the evidence was gathered.
Mm-hmm.
So yeah, but that really wraps up everything that I wanted to say so far. What about you?
It actually wraps up. I feel like I've said everything I could say in the CPS and the criminal procedure should it be ventured into, and the potential sentencing. I feel like I scratched the surface in terms of what assault could go down, but
I mean, we're only
BTP
scratching the
completely
surface. I
denied
mean,
the assault.
once we get the evidence, or once we get the CPS's view, I think then we can come back. And I would think it will be very interesting to me to see the CPS comment on corporate manslaughter and
Definitely, I
whether
can't
that's going to
wait.
be.
I'm anticipating whatever the CPS is going to say. Do I have a feeling of how it's going to go? I'm very unsure. It could go, we're gonna go the criminal route, or we could go down the civil route. It's tricky. But the big question in here is intention. Did he have the intention? And how do we prove that she got COVID-19 from this individual? So I
From this
feel like the
incident.
energy should also be focused on her employer.
Big, yeah, really, I
It's a
agree.
question, I think.
Yes.
Do the courts take similar approach to consent in corporate criminal sense as they would in a civil sense, i.e., the courts are extremely unlikely to take consent as a defense in an employment context?
So, so what that's asking is, for example, if you're bringing an employment case and the employer says, "Oh, but you said that you would work overtime," it doesn't change the fact that it was unsafe to make them work overtime, or allow them to do it. So,
Mm-hmm.
what's being asked is, when they're looking at corporate manslaughter, is it a defense to say, "Oh, but they said that they would go up on the roof and work"? The answer, and short answer from what I've seen, is no. That's not a
No.
defense. I will go through some of the possible defenses that have flown in
Mm-hmm.
court before. Um, but of course, I clicked off the page.
No consent to anything other than GBH. No, above GBH. No.
As in, you can't
Wait.
consent to GBH. You
You
can't
can't
consent
consent
to.
to GBH. No, you can't consent to GBH.
I think the same would be
Um,
applied here. So I'm just gonna have a look.
in the civil sense.
Yeah, I don't think there's any, no, in the corporate manslaughter sense. I'm just having a look. You
Oh
can't
no.
consent to an act that will end up killing you. Just give me 1 second. I'm just having a look at
Huh?
appeals. Um, and seeing what
I work
successful
that would be
appeals
bad,
have
so
been
don't
made.
worry.
I'm just having a look. I think that's my. Who is it? Hi, Arthur. Open the door, please. It's my 3-year-old brother. I'm sorry, everybody. Yes, Arthur. You need to go to the toilet. But I'm doing something on my computer right now. Can you wait a minute? Why don't you go by yourself and then I'll come in a minute? Okay? Okay, I'm coming up. Right, so I have to wrap up because my little brother needs me to take him to the toilet.
Yeah.
But I'm just having a look. I've seen appeals against conviction.
Mm-hmm. Okay.
These were more evidential in terms of statements used in court. But I haven't
I'm
seen.
just trying to read. I'm trying to read through a few more cases in terms of assault, if they were to consider assault, and I'm seeing actually they've said they've sentenced some people to actually to 13 months for spitting, custodial. 36 weeks. I'm seeing 16 weeks. I'm seeing 12 weeks in prison, suspended for 12-week curfew, and ordered to pay £100. Mm, mm, mm. For real. Mm.
For real.
And this is all in relation to people spitting and coughing, claiming to have COVID-19, by the way.
So the claim to have COVID-19 is what has
The
contributed.
claim to have COVID-19.
And the maximum sentence appears to have been, what, 12 months custodial?
Well, custodial, yeah.
So that means 12 months in prison. So
In prison.
these are all things that we're gonna expand upon and look at as the case continues further. But if nobody else has any questions, we're
Any
actually
more
gonna wrap up the
questions?
stream.
Yes.
But thank you so much, Benny, for coming on and for
You're
your
welcome.
amazing
Thank you for
research.
having me. Thank you.
I want to remind everyone again that this live stream is available in full on YouTube. And also that if you do want to see the case research that Benny has done and that we'll continue to do for this case, then send a DM to either her or myself and we can make that happen for your own research and knowledge. But yeah, I just want to say thank you for coming on. Thank you, everybody, for
You're
tuning in
very
to
thanks
this.
for having me.
Thank you. It's a pleasure. And thanks, everyone, for tuning in. I will see you for further live streams. And if there aren't any further updates in the George Floyd cases or the Belly Mujinga cases that need to be addressed first, the next live stream I'm going to do is on the case of Breonna Taylor, which I'll get into more in my actual posts. But thank
Can't
you,
wait to watch.
everyone.
That'll be interesting.
Yeah, thank you. But thank you, everyone. Please continue to stay active and demand justice for people who have died wrongfully.
Make sure
And
you open your purse. Donate.
open your purse. Donate to organizations and charities who are committed to addressing the systemic issues that we're all campaigning for. And if you are stuck for resources, I will provide a full resource list as a link in my bio so you can continue to show your support and solidarity in action and not just in performance. So thank you, everyone. Thank you, Benny. And bye to everyone on Instagram and also bye to everyone on YouTube. Okay,
Bye,
bye.
everyone. Bye. That was fun.
And I'm going to wrap this up. Hi. So we're just going to say bye on YouTube as well.
Thank you.
Bye to everyone on YouTube. Thank you so much. And Ben, if you could do me a favor before we lock off.
I had a good day. Oh my God.